Okay, so ako po si Armand Mejia, no? Ako po ay miyembro ng MedNet, no? And ako po ay naatasan this morning to serve as the moderator for this discussion, no? So if you are here, then you are joining the discussion on agrarian dispute resolution. Okay, so sinabi kanina that there are two other discussions going on parallel to us, no, simultaneously with us. So ibang ano naman yon, ibang areas of conflict resolution, but for our particular purposes dito sa ating group, no, dito sa ating breakout room, this is agrarian dispute resolution. Okay, so welcome to everybody who is here, no, all 17 of participants who are here this morning. So allow me to begin. I was informed, no? So we have invited two resource persons, two panel discussants who are deeply involved in the work of agrarian reform, particularly in dispute resolution among parties or stakeholders in agrarian reform, no? So this morning we are joined by two of them. Our first presenter is Miss Victoria Delgado. We call her Vicky in MedNet, no? So I'll go through her bio. She's with the Department of Agrarian Reform, Negros Occidental for 32 years. No? So she started as paralegal officer, became legal officer 1, legal officer 2, Senior Agrarian Reform Program Technician, and Municipal Agrarian Reform Officer in Cabangcalan City, Sagay City, and presently in Manapla, which are all in Negros Occidental. And Vicky has been with MedNet since 2005. And as such, she became VP, Vice President for Visayas, and Vice President alternate also for Visayas. And Vicky is an accredited mediator of the OADR, that's the Office of Alternative Dispute Resolution of the Department of Justice, which accredits mediators and organizations. Okay, so by way of background in educational attainment, Vicky is a graduate of Bachelor of Science in Commerce, major in Banking and Finance, Bachelor of Law, no, with a degree in Juris Doctor, JD, and a Master in Public Administration. And she adds proudly that she is a mother of 4 and a grandmother of 8. Okay, so let's all welcome our first presenter, our friend and colleague, Miss Vicky Delgado.
Good morning, ayong aga sa tanan. I would like to start our discussion regarding agrarian dispute. As a backgrounder, the Department of Agrarian Dispute has the jurisdiction to arbitrate or handle agrarian cases. When we say agrarian cases or agrarian dispute, any controversy resulting to tenurial arrangements, whether leasehold, tenancy, stewardship, or otherwise over lands devoted to agriculture. The Department of Agrarian Reform handles cases during the Presidential Decree number 27 or the Operation Land Transfer, wherein we are issuing certificate of land transfer and emancipation patents. This is during the time of President Marcos. And it covers tenanted agricultural lands in excess of 7 hectares. While Republic Act 6657 has a broader coverage wherein it covers public and private agricultural lands and in excess of 5 hectares, and we issue certificate of land ownership award as title. So I am going to give an example of the litigated case that we handled in the Department of Agrarian Reform. We handled mediation cases those cases that we cannot settle within the Department of Agrarian Reform. This is also a prelude wherein we issue a certificate of non-settlement where we can file their case before the Provincial Agrarian Reform Adjudication Board or the Department of Agrarian Reform Adjudication Board. So can we start? I have this title as sentimental value, considering that this involves a controversy between members of the family and another third party. So as a background of the case, uh, the first slide for the background. So the background of the conflict is an agricultural land with certificate of land ownership, certificate of land transfer, meaning it was issued during the presidential decree number 27 in the name of the grandfather who dedicated his family, cultivated and made subject farmland productive. So usually, since it is a tenant landlord relationship, most of the family were the ones cultivating subject farmland. Upon the death of the grandfather, the subject real property was entrusted to the youngest child, but the said child looked for another job and he entrusted the real property to his older brother, meaning the older brother also with the aid of his family and the family of the grandfather also cultivated the subject land. But later on, his older brother was the one who took care of their father to sustain his food and medicine. When the elder brother got sick and also needed medicines for his medication, he was forced to lease the real property to a private individual not related to him. Next slide, please. Okay, what are the issues? So it's a 1.25 hectares agricultural land. So when the other children knew about the transaction, the elder brother has no insist that the elder brother has no right over the farmland as it was not entrusted to him, and he misrepresented himself to be the rightful owner thereof. Even the wife has no right to have the farmland leased to any other third party, and that the lessee has spent a lot. He has no right to lease the farmland to any other party, considering that the subject land was registered or issued in the name of the father of the tenant. So the lessee came into the picture because he was the one in possession of the farmland, wherein he insisted that the members of the family cannot take over possession of the property, considering that he spent a lot of money in planting, in cultivation of the property, and already make some advance rental payments to the family. So the rest of the siblings would like to take possession of the real property. So the tension was very high in the field level because there were three contending parties on the farmland. Okay, next slide, please. So who are the stakeholders? The youngest brother. With the youngest brother, with the full support of the other siblings, including the nephews and nieces, wherein they demanded for the return of the farmland to him, especially on the cultivation and the planting in the farmland. Since the lifetime of the original tenant, their father, the farmland served as the source of their livelihood. It has also helped them a lot to go to school and earn college degrees. The elder brother asked the youngest brother to allow him only to take possession and cultivate the farmland in order to help his family members in their day-to-day living. So being brothers, he outrightly paved the way and turned over the possession to his elder brother with the understanding that any member of the family could also borrow and be allowed to cultivate farmland when entirely. This is usually present in the field level wherein it's parang the ownership of the property is reliebo or masa wherein they take turns in cultivating the subject property because so that any family members could also earn some income during their term. Next slide, please. So we have the youngest brother, the children of the nephews, the other brothers and sisters were in the children of the tenant with the nephews and nieces, because some of the brothers and sisters died, so they are represented by their children also, so the nephews and nieces, including the grandchildren of the deceased tenant. They claimed that the subject farm lot was previously cultivated and in possession of the youngest brother, but for only humanitarian reasons, they allowed the elder brother to cultivate the farmland. And the widowed wife leased the said farmland to another person, and he opposed the said transaction. For them, the farmland has sentimental value to the family, and they would want to take possession of the farmland from the lessee. The other stakeholder, we have, next slide please, the widowed wife, who refused also to return and eject the lessee to the farmland, for the reason that during the lifetime of her husband, her husband was the one cultivating the farmland. And even during the identification of the Department of Agrarian Reform, the screening, her husband represented himself as the beneficiary or the actual tenant or occupant of the said farmland. That when the father-in-law got sick, they incurred a lot of debts, which was aggravated when her husband also needed money for the medication, hospitalization, and the burial of the husband. And she had no other recourse but to have the farmland leased to the lessee to also pay their debts for the expenses that they incurred. So we have the three stakeholders in the subject property. And for the fourth stakeholders, we have, next slide please, the lessee who refused to return the farmland to the huge amount of money that he advanced to the wife, which also form part of the leased rental and the expenses that he incurred in planting and cultivation. And he has yet to harvest the newly planted palay, and he has 3 years more left to cultivate the land under the terms agreed with the wife and the eldest brother during when the elder brother was still alive. Next slide, please. Okay, so what are the mediation steps? The oral or verbal complaint was filed by the complainant to the office. We have the complainants, the younger brother and her niece, and giving the narration of facts and the available documents to support the complaint. They presented the death certificate of the father, the birth certificate, and also they have also some pictures of the farm lot, and they have pictures during their younger years wherein they stayed in the said farm lot. Upon listening to their complaint, we again also invited the person complained with the complainant for an interview. So we invited the widowed wife and the lessee. So from the information gathered, so also some documents and facts on what transpired or what happened in the area. From the information gathered during the interview and other available documents in file, we scheduled both parties for a mediation conference. We served the mediation letter stating the date, time, venue, and purpose of the mediation conference. Next slide, please. During the mediation conference, in order to get fully the pulse of the parties, shuttle mediation was conducted, wherein in separate days the parties were told to know their sentiment, and if there is any way they could enter into an amicable settlement. The shuttle mediation was on schedule. When we set this mediation, we find out that napakainit yung aura ng each parties, dahil considering that we are family members, merong mga toxic na mga words from the other parties, wherein sometimes we have to call some recess or make them also aware na each one should also respect the other position or issue raised by the other parties. So we have to call for resetting also some mediation and the schedule again other other dates for them to explain their sides. On the second day of shuttle mediation, on a heated argument ensued which necessitated a call for caucus or recess to give the parties to cool off for a while. Next slide, please. So what are the outcomes? On the scheduled mediation conference, the attendance of the complainant was overwhelming because of the other services are also in attendance. Napakarami nila. Siguro mga 6 to more than 10 persons only for the complainant side. The widowed wife, tsaka yung anak niya, and the lessee, meron siya tang kasamang isa. So they are all in attendance for the mediation conference. Both parties are highly emotional, which is a common scene when the parties involved are family members. Next slide, please. So, even na ganun yung mga situation, naiano namin yung nahatak namin yung parties to a mediation conference. I-ano na lang natin yung muna yung agreement, baka yung sa slide. So, yung bang yung napag-usapan? The rental advance to the lessee shall be reimbursed to the lessee. Babayaran na lang yung anak, though yung lessee nakabayad na sa widowed wife, inaano na lang nila na ibalik na yung lease rental na nagastos ng ibigay na ng lessee for the lease. They also allowed the lessee to harvest the standing palay in the forthcoming harvest. Mga 1 month na lang siguro pwede nang ma-harvest, and after na ma-harvest, they could take possession of the land. And also the complainant should be allowed to finish the term of the lease, meaning kung meron siyang 3 years na lease yung lessee, the complainant shall also finish the 3-year lease contract of the lessee and shall pay the land tax and amortization with the Land Bank of the Philippines in the name of the brother. After the complainants harvest their palay on October 2025, peaceful possession shall be turned over to the widowed wife. A kasugtanan was forged between the parties and have said amicable approved by the parad. We usually approve the kasugtanan with the parad, meaning the Provincial Agrarian Reform Adjudication Board in Negros Occidental, wherein they conducted also a confirmatory hearing kung saan they called the parties in the kasugtanan and confirmed if the same was duly entered into freely and voluntarily, and that they agreed with the terms and conditions stated in the kasugtanan and caused the approval of the said kasugtanan. So that will strengthen the kasugtanan that both parties should observe the contest of the kasugtanan also. Next slide, please. Okay, so mediation techniques that work. Before the start of the conference, the setting of ground rules that should be observed by the parties. Mostly, sometimes they could give also a limited or a little ground rules. We have also to ask questions if it is all right, if we shall limit the number of persons to inside the room, or if we cannot avoid that, if we could sit in and just observe, and if they have other questions or during the mediation conference, they could raise it by giving a short note to the person appointed as spokesperson during the mediation conference. Next slide, please. Okay, what helped the mediation and what hindered it? Clear explanation and understanding of the respective rights of each parties, and the explanation. It is also a trust. The parties have also a trust with the Department of Agrarian Reform for giving us who has the primary jurisdiction to hear the agrarian dispute. mostly all agrarian dispute, because of we have full trust, they could it could help in the mediation process. The other party has the sufficient resources to pay off the lessee that resorted to a peaceful turnover of the farm lot. Dahil naman po we have the money or the resources to pay off whatever payment, they they were able to get possession of the subject property. Next slide, please. Sa hindrance naman po, I just want to raise the hindrance. There are no hindrances during the mediation process. In fact, the full cooperation between the parties is highly overwhelming. They want also to get a peaceful and harmonious relation, and maintain also the relationship among the family members. But the lessons learned, a mediator should be fully equipped with a lot of patience, must do research and interviews to get a wider sphere of the controversy. Medyo yung baon natin sa pasensya at paano natin i-handle in cases of some harsh words or toxic words, paano natin yan pacify yung both parties. Able to communicate and lead the parties to a clearer picture on where they are leading, the pros and cons, more particularly the number of years it will take if they will file a case in court, and monetary consideration for the fees and their other expenses that they may incur. And a full understanding and cooperation among the parties can help to lead the parties to an amicable settlement.
Sir, may I, sir?
Yes, please. Can you, perhaps we can, since hindi tayo magkakilala lahat dito, we can ask those who are going to ask questions, like Attorney Al-Rashid, to just give a short introduction, where we are from, what work we do, no? And then we can ask our question. Go ahead, sir, please. Thank you.
Okay, thank you, sir. I am Attorney Rashid Manbal, the Regional Director of the Ministry of Public Order and Safety of the Bangsamoro Autonomous Region in Muslim Mindanao. Our agency is also working on settling disputes, although in the traditional way of settling disputes existing in the region. So we are very interested, and we are thankful for being invited in this conference, sir. My question is related to the jurisdiction or scope of the agrarian disputes na falling within the ambit of the DAR. Yung kasi, sir, yung binigay, yung case na discuss ni ma'am, parang nakaka-relate kami. May mga existing disputes na almost similar lang yung facts. So ang tanong ko, sir, is kasi hindi masyadong klaro sa akin yung ano ba yung mga jurisdictions or yung cases falling within the authority of the jurisdiction ng DAR and sa Darab, kasi baka itong cases pala na nandun naman, pwede pa lang ipasa, for example, sa DAR. Yun lang, sir. Maraming salamat.
Regarding doon sa we have the I already stated the definition of an agrarian dispute. It's a controversy relating to tenurial arrangements, whether leasehold, tenancy relationships, or otherwise over lands devoted to agriculture. Usually, yung sa Department of Agrarian Reform, we handled cases those covered with certificate of land transfers, yung title, yung Emancipation Patents and Certificate of Land Ownership Award, wherein they are beneficiaries of the Department of Agrarian Reform in the implementation of Presidential Decree number 27 and Republic Act number 6657 as amended by Republic Act 97. In fact, in the recent case, meron na siyang yung primary jurisdiction is affirmed nasa Department of Agrarian Reform on ang mga to adjudicate sa mga agrarian cases controversy. So, yun ang ina-handle natin sa I-refer lang yung sa sir, yung sa Department of DARAB Rules and Regulations. Meron tayong bago. Meron doon yung mga jurisdiction na ina-handle ng agrarian DARAB Rules and Jurisdiction, wherein nandoon yung jurisdiction kung ano yung mga cases na pwedeng ma-file considering that the DARAB is a quasi-judicial body na nag-handle ng mga agrarian reform cases or agrarian dispute.
Ibig sabihin naman yung mga cases na yung land ay unregistered, wala na yun sa
Wala sa hindi. Wala kaming regarding sa yung mga usually ang namin is na-handle. Meron ding mga yung mga transfer certificate of title. You're referring to that, sir? Wala. Sa regular courts yan. So we have emancipation. Pero they are also handling, sir, cases of just compensation, yung sa DARAB, regarding doon sa na-cover na namin mga properties and that the landowners are not, do not accept the valuation given by the Land Bank of the Philippines. The same is through summary na namin pino-forward with the Provincial Agrarian Reform Adjudication based on the valuation jurisdiction. Parang may 1 million to 5 million na sa PARAD and the 5 million and above Regional Agrarian Reform Adjudication Board and more than 10 million yata sa DARA from Manila. Do you have, sir, any specific case regarding na hinahandle regarding land dispute or agrarian dispute?
Yeah, may mga instances, ma'am, kasi na may na-refer sa amin na almost the same yung facts. Yung lupa ay pinag-agawan ng mga within this members of the same family kasi namatay nga yung lono nila. But yung siguro yung kaibahan na unregistered yung land kasi nga sa sa region, ang daming unregistered lands may mga conflict.
I suggest, sir, yung mga unregistered land, file tayo with the court for the issuance ng mga titles. And then meron din pong mga titles, yung mga homestead patents na ini-issue ng Department of Environment and Natural Resources. But we are issuing emancipation patents and certificate of land ownership award. You're welcome, sir.
Thank you, sir. Attorney Balt, Attorney Rashid, for that question, and Ma'am Vicky for her response on issues of jurisdiction. So I think yung bar, meron din silang structure, parang may autonomy. So I think there's also a body there which handles agrarian questions, if I'm not mistaken. So thank you po. We recognize Carol Pederos
thank you.
from Mednet.
Thank you. Clarification lang, Miss Vicky, baka hindi ko masyadong nasundan. Yung complainant was the lessee?
No, yung complainant, yung mga anak ng mga certificate of land transfer holder.
Oo. Kasi doon, sa agreement, the lessee will be paid by the complainants.
By the complainants, yung mga anak at saka yung nephews and nieces na ng original na tenant.
Kasi gusto nilang makuha, di ba?
Makuha.
Oo. Second, So babayaran nila and then harvest kasi may 3 years pang term, 'di ba, sa lease. So ang napagkasunduan nila na sa harvest time within that remaining 3 years, ang complainants na ang mag-harvest. So
Yes,
hindi
sila
na
na.
yung less.
Yung less oo. So yun na.
Ano po yun? Yung bayad nila was parang bulk? One payment or installment?
Nang kasi sila nagpulo sila ng ng pera kasi yung seaman na. So meron silang pera.
Mga pera sila. Okay.
So,
pero it's interesting na binalik nila sa widow ang lupa.
Hindi pa after 3 years pa.
After
yung lease,
harvest, ibabalik nila.
Yes.
So kasi diyan ako curious dahil gusto may sentimental value. So that this meant that they agreed to give the right to possess the land, the inherited land, which is valuable for all of them.
Yes.
They agreed to give the right to possess to the widow.
Yes, after 3 years na.
After 3 years. Meron ba sa kanilang agreement na clause na bawal i-lease uli, bawal ibenta, mga ganon?
Although behind that yung mga complainant pending doon sa possession nila, meron silang pina-file for the disqualification na na lang natin yung agrarian law implementation ng Ali case for the resolution naman nung sa office for the disqualification on the basis na nag-alis yung wife and then kina-question nila but parang may misrepresentation from the widowed wife at saka yung sa elder brother na siya yung nagpa-register at nagpa-identify. So, hindi ko na lang i-state kasi bilang sa mediation. And then, ang lang is yung possession na makapasok yung mga complainants. Makuha sa ST.
So, pero ano pala siya? It's still, one issue was resolved, but there were other sub-issues na ongoing na ayusin.
For Ali case and for the resolution of the regional director which is separate from us sa municipal level. Yeah.
Okay. So, thank you. So, sa akin, ang insight ay pag ganito, there are many issues of conflict, no? In relation to possession of land, possession and cultivation, no, na sa ganitong context na namatay na ang primary beneficiary ng tenant. Sige. Okay. So the challenge for mediators, you said, is kailangan mahusay ang pag-investigate ng case and then prioritize which one is possible where possible ang agreement, no, para maging successful.
Okay.
Yung by the way, concern ako sa gender balance sila. Yung complainants ba majority lalaki o babae?
Actually, yung pumupunta sa office babae.
How was
babae
their
mga out of 6, mga 4 yung babae, 2 yung lalaki.
How was their communication exchange? Nangingibaba ba yung value ng family or very competitive?
Nangigababaw yung value ng family. Meron pa rin silang respect doon sa tiyahin kasi pag okay man lang yung pwede nilang ma-take over yung lupa without going sa DAR. Pero pa rin nila yung diplomacy at saka yung respect sa tiyahin nila. So yun dinadala yun.
Okay. Sige. Nasa medyo rural area pa na malakas pa ang value ng respect, value ng family.
Values.
Oo. Okay. Kasi may kaibahan yan pag urban, malapit na sa urban, no? Lalo na yung malapit na sa mga converted areas,
Yun
no?
na yun. Oo.
Oo, nag-iiba. Sige, thank you very much. Yan lang po.
Thank you, Miss Caron.
In the interest of time, we will proceed with our second presenter. No? So, palakpakan natin si Miss Vicky.
Thank you, Armand. Thank you, everyone.
Thank you, Ms. Vicky. Thank you. Always a pleasure to listen to you talk about agrarian dispute resolution. Pero meron pa tayong isang resource person and it is my honor to introduce him now. No? And again, in the same way that I introduced Ms. Vicky, let me just his bio na binigay sa atin para makilala natin sino ba tong next presenter natin. Mr. Floro Floracil Z. Astillo was born in March 18, 1971 in Tubigon, Bohol, but now presently resides in Tagum City, Davao del Norte. So nasa Mindanao siya, Miss Vicky was in Visayas. He's married to Mary Teribel S. Lasay and they have 2 children. He finished his bachelor degrees in Bachelor of Arts, major in Political Science, in the University of San Carlos, Cebu, and Bachelor of Laws in the Ateneo de Davao University. No, like Miss Vicky has been employed in the DAR, Department of Agrarian Reform, for 22 years, and currently is a MARPO, Municipal Agrarian Reform Program Officer, and is assigned to one of Davao del Norte's municipalities. As DAR employee, it is one of his most important functions to conduct mediation conferences involving agrarian-related disputes, and as such, has undergone a number of trainings and seminars on mediation. And like Ms. Vicky, he is our beloved colleague in MedNet, one of us also. So let us now warmly welcome and listen to the presentation of Mr. Floro Astillo.
Good morning. Marinig ako, attorney? Marinig
Yes,
ako?
yes, okay lang.
Okay.
Narinig
Sige.
naman. Thank you.
Salamat, attorney Amang. Good morning, may buntag, may maaga sa ato ang tanan. And just like Miss Vicky, I will be presenting to you a case concerning agrarian dispute as an employee of the Department of Agrarian Reform. I'm so happy Miss Vicky has presented to us what is the coverage of agrarian dispute concerning the Department of Agrarian Reform. So, as a Municipal Agrarian Reform Program Officer or any employee for the DAR for that matter, who handles mediation, we face different kinds of agrarian disputes, but I will be presenting to you one of the most common problems or issues, disputes that we face from since I was first employed as a legal officer until my present position right now as MARPO. These issues or conflict still subsist. So, okay, so this is the background of the conflict. This is actually a conflict between a tenant and the landowner. So, the tenant farmer has been working on the land for 25 years, and he just succeeded his father, late father, who was the original tenant of the landowner. The land holding involves 2.5 hectares devoted to rice production, and with the sharing of or lease rental of 75%, 25% in favor of the tenant. As I said, the tenant took over the place of his father, and the landowner involved is also the heir of the original owner. Next slide, please. So the issues involved in this agrarian dispute is the alleged failure of the tenant to comply with this obligation. That is to give to the landowner the supposed share or rental every time the harvest of the rice production is done. So the landowner complained of the failures committed by the tenant and demanded for the tenant to stop working and surrender the cultivation to the landowner. And the landowner accordingly sent a letter to the tenant giving him one last harvest without giving the share. So meaning, what will be the proceeds of the harvest will be all for the consumption of the tenant. So in response to the letter, as the information was gathered, the tenant accordingly went to see the landowner to negotiate. But then the landowner has shown his resolve in ejecting the tenant and even questioned the personality of the tenant since he just succeeded his father. And according to the landowner, it was the late father who is only considered as tenant, but not the present one. That was the allegation of the landowner. Next slide, please. Okay. So the stakeholders of this agrarian dispute are the following. We'll just name the tenant as Mag-uuma. And then, as part of his admissions, he said that while he admit his failures, he reasoned out that the same were caused by fortuitous events, floods, pests, and all, which were beyond his control, and declares that in time he will pay his shortages to the landowner. He insisted that because of the long period of time, he cannot easily be ejected from the land he is stealing. And he made a declaration that farming is his family's only source of livelihood, and he still has children to send to school. That is why he's really bent on staying on as tenant of the land, and while he admit his failures, he reiterated that he will pay his shortcomings, the shortages to the landowner. For the landowner, we will refer to him as the Agalon. And as a landowner, the usual arguments of landowners he did not believe the excuses of the tenant. He's stating that he's already fed up of his alibis and stood firm on his demand to eject the tenant and just give him one cropping. He added that for the past 25 years, his family was not able to fully enjoy their only agricultural land because of the presence of the tenant, and feels it is high time for them to personally cultivate the land, adding that his family also needs other resources to augment their source of income. Next slide, please. So, of course, as part of the stakeholders in the mediation process, I should not forget, or we should not forget that the BARC, or the Barangay Agrarian Reform Committee, and the officers are involved in the mediation process. So, as the mediation steps taken, the parties were first mediated by the chairman of the Barangay Agrarian Reform Committee, where Mag-uuma, or the tenant, lodged his complaint. According to the rules followed by the office, if there is an agrarian dispute and it has to be mediated or undergo mediation, it has to go through first with the BARC, with the aim of settling the dispute in the barangay level. However, during the conduct of mediation in the BARC, the same did not prosper. So then, the BARC endorsed the case to the DAR Municipal Office, or the DARMO, or the MARO. So, as part of the process, after the receipt of the endorsement, The Maro made schedule, sent the letter invitations to the parties involved, and set the schedule, the time, the place, and the date of the mediation process to be conducted at the office of the Department of Grand Reform as a neutral ground for the parties to engage in argument. So during the time of the mediation, the parties just reiterate the arguments as contained in the endorsement, and the mediator noticed the high emotions running between the parties. So, having sensed that if we will continue with the process of mediation by parties talking and talking, the mediation will not go elsewhere, and it will just worsen the situation. So it was the call of the mediation to cut the process for a recess, just to cut the tension and ask the parties if they are still willing to continue mediation. When they answered in the positive, I told them that a caucus will be undertaken in which the parties will be conferred with separately to break the tension. Of course, I made it a point to explain clearly to them what caucus is all about, so that we can do away with any suspicions from either party. Next slide. Okay. So during the caucus, it was the turn of the tenant to be conferred with by the mediator. The tenant admitted that his failures were actually a mix of fortuitous and intended events. The latter was because of dire financial needs. And he admitted having failed to seek first the consent of the landowner. And he expressed his desire to continue working because he has no other source of livelihood to support his family. And he promised to pay his shortages and even offered to cut his share in every harvest. So, yun ang sinabi sa mediator ng Bago-Uma, just to make a point of discussion or point of negotiation or something to talk about with the landowner when we resume. So, when it was the turn of the landowner, the latter laid down his dismay and frustrations towards the tenant because he made him feel that he has more right over the property and that he is protected by law as a tenant. So probably during their prior engagement, baka sinabi sa kanya ng tenant na matagal na kami dito, hindi kami mapapaalis, apektado kami ng DAR, probably, may nakapagsabi. So, during that time, the landowner really felt na frustrated siya talaga doon sa tenant. We got fed up with the tenant's demeanor. Nonetheless, and this information came from the landowner. And in consideration of them being relatives, somehow magkadugo pala yung dalawa, he is willing to give chance to the tenant, but stressed that he will really pursue his desire to personally cultivate the land. And the most that he can offer is an extension more than the one cropping initially. So, yun ang sinabi niya sa akin sa during the focus na pwede niya pagbigyan, pero di talaga yung parang lifetime, kundi extension lang ng doon sa nabigay niya na initial offer na one copy. Next, please. After the caucus was done, the mediator were separately consulted if they are ready to resume with the mediation. And so when they expressed their willingness, the mediation continued. It was done in one setting, in one day. We did not make postponements or just made a recess, and then caucus, and then resumption of the mediation. The mediator can still feel the tension, but it was noted that the parties were already more relaxed, and so the exchange of words, arguments, allegations continued until they reached an amicable settlement. And the content or the meat of the settlement was focused mainly on their common interest in providing source of livelihood to their families. Next, please. So the outcome of the mediation, the parties entered into an agreement giving the tenant 5 years to further cultivate the land without sharing. So lahat ng makukuha ng tenant for the next 5 years or 10 croppings will be for his family, only for his consumption. And his shortages will be condoned. And after the 5th year, mag-uuma will voluntarily stop cultivation and surrender the area to Agarian. This agreement was not right away entered into, meaning medyo mataas-taas pang discussion, but this is the end of their arguments and exchange of ideas. So I conferred with the landowner if naintindihan ba niya for the next 5 years wala siyang makukuha. Sabi naman niya, we have waited for 25 years. We can wait for another 5 years perhaps, sir, but at least for the next 5, after the 5th year, makikita namin na kami na naman. So yun yung makikita ng positive. And I told the tenant, alam mo ba na after 5 years, wala ka nang makukuha. Hindi ka na magtitenan, hindi ka na mag-aararo dito. Naiintindihan niya rin. Sa kanya lang, after 5 years, may his children, or some of his children will be done with their schooling by then. Kasi sabi niya, yung nakuha na ng anak niya, naman yung mga ng mga kurso. So nakikita niya after ng 5 years, matutulungan siya ng anak niya sa pangkabuhayan. I told them, if you enter into this agreement, this is your agreement. This is not enforced or introduced by the DAR. This is your agreement. Naintindihan naman daw nila. So next please. Next slide please. So yun, I told them when they entered the agreement, sabi ko, you have to have this document be notarized so that it will be more, it will be more strong, compelling on either parties. So sabi naman nila, yes, we will do that, sir. And copy of that agreement will be given to the bar chairman so that yung barangay naman guided sa problema nila. So lessons learned during the mediation. It is important that the mediator will not rely solely on the narrative situation made in endorsement. He has to personally talk with the endorser, the bar chairman, or gather more information from other sources. Although during the mediation, this may come out, it is better that the mediator already has a prior knowledge of some facts. In the case at hand, the mediation technique that worked among others was the conduct of caucus, among others, because all the preliminaries were done. Those preliminaries were effective, but ang naging susi talaga ng agreement is the caucus, to my mind. But it has to be noted that the amount of technique can prosper if the disputants will not coordinate, not open-minded, and remain hostile throughout the process. So it is important that the mediator has the patience and ability to observe the demeanor of the parties. And it's also important for the mediator to know the law. because of, for this instance, when the landowner argued that a tenancy cannot be subject of succession or it's not an inheritance, I explained to the landowner that it is not really an inheritance, but the law allows succession in tenancy in some cases. And so it is important that a mediator, especially when the parties will question on that, you have something to answer based on law, not on your opinion. That is all for my presentation. Daghang salamat.
We are supposed to rejoin plenary by 11:30. So we only have 9 minutes left. Maybe we can have time for just one short question kung meron man, and then I will wrap up our time together here in this breakout room, and then we will rejoin the plenary. Zito will help us all go back to the plenary. Okay, so any questions, any reactions? No? Sorry, we do not have time. We masyadong maikli yung ano natin. We have many. Sige, Ma'am Vicky. Yes, go ahead.
Just a short comment lang.
Yes.
Hi, Floro. Long time no see.
Hi, Vic.
Yung ano pala, mabait yung ano, yung landowners, tsaka yung sa tenant. In fact, yung ginawa ng ano, yung tenant, diba? Parang force majeure, merong fortuitous event, hindi naman voluntarily, hindi siya nakapagbayad. Diba? Under sa law natin, meron siyang 5 years. Yung pinasok nilang kasultanan is a sort of a waiver of rights ng tenant para hindi na siya maging tenant doon sa subject property, which will put an end yung sa landowner-tenant relationship. The subject kasultanan was approved by the court or hindi na? Compliance na lang. Compliance na lang. Okay.
Anyway, pinanotaryo yung agreement. Becomes a public document.
Ay, okay. Thank you, Floro. Yun lang. Attorney Armand.
Thank you, Ma'am Vicky. Thank you for your response, Floro. Okay. Anyone else? Last na talaga before because I only have around 7 minutes to wrap up. Okay, so meron dito sinabi basahin lang natin siguro, BS Minandang, one of our participants. Basahin ko lang, it's not easy to have a tenant. Those who don't have tenants don't give chance not to have such tenant.
Tama yun.
So nag-agree si Floro dun sa observation. Well, that is the law, di ba, Floro?
Yeah, yes.
Yan talaga eh. So, because this is sabi nga ng mga taga-DAR, this is a social justice legislation. So, syempre, protektahan din yung mga medyo mas mahina, di ba? Between the two, di ba, Ma'am Vicky? Floro?
Yes.
To protect those who are mas mahina doon sa bargaining position.
Those who have less in life should have more in law.
Yes. Tama. Sabi din ni Floro. Those who have less in life have more in law. Unfortunately, that's the law. We should follow it. No? So if you are the landowner, medyo yan ang limitations mo talaga. Okay. Sige.
Ako may tanong. Short lang, very short.
Go ahead, Carol. Go ahead.
Sir Floro, ano yung technique na nag-work? Kasi parang sa beginning narrative mo, very insistent, parang ayaw na gusto na talaga ng landowner na i-eject ang tenant, no? Kasi nakailang beses na siyang hindi nag-comply, no? Although sinabi nung kabila na anong tawag, hindi naman niya sinadya at magbabayad siya. So nung sa caucus, you mentioned that that's the major important strategy. Kasi mataas yung anger. So what made the landowner change his mind na pagbigyan? Kasi ang understanding ko, galit na siya, puno na siya sa mga pangako, gusto niyang makuha yung lupa kasi it's been 25 years. So ano po tingin mo ang nag-work when you did your caucus?
I think yung ang pinaka-substantial doon is parang na-consider niya na during the caucus and after the discussions, yung consideration niya na relative pala niya yung yung relative niya yung kabila. Yung, yeah, and then
My
kasi
blood
naman, siguro,
relations.
yeah, oo. Yun lang nasabi niya. Siguro kung wala yung consideration na ganun, probably iba yung ano niya. But sabi niya, may mga anak pa din kasi nag-aaral. So somehow, ganun na lang ang consideration.
Okay.
Yun po ang nakikita ko, Ms. Carol.
Okay, sige. Thank you very much. Yun lang po.
Amping.
Thank you, Carol. Thank you, Carol and Floro. Okay.
Thank you, Attorney.
Unless someone else wants to say something, I will wrap up already because it's 11:27. Okay? Thank you. So, like I said, medyo we have a limited amount of time and I'm sure marami pa tayong gustong itanong sa ating two presenters, but unfortunately, we have to wrap up at this point, no? So, by way of synthesis, no? So, thank you. First of all, I'd like to thank Floro and Ma'am Vicky for sharing with us their experience, no? Long experience in resolving disputes in the DAR. So, tagang salamat, damo nga salamat sa inyong dalawa. Thank you and thank you for your time po for sharing it with us. No, and I would also like to thank the participants, no, na nandito this morning. I know you have picked up something from our discussions and the limited question and answer, no, but we will learn more, no, as the conference unfolds, no. So gusto ko lang i-highlight siguro yung taking off from the last comment of question of Miss Carol, no. Siguro doon sa dalawang presentations, no, the first was a tenancy dispute pareho, no? Well, yung second talaga tenancy dispute kay Floro. Kay Ma'am Vicky parang may pagka-ali case pa, no? Agrarian law implementation, so dispute between the beneficiaries, no, yung mga heirs of the beneficiary. So for them, no, gusto ko lang balikan yung kanilang observations, what worked for them. Sabi ni Miss Vicky, what worked for them was laying the ground rules, no, early doon sa mediation process para maging klaro, para hindi sumabog yung discussion, hindi mag-away-away yung mga participants in the process. No? And it helped also that kinontrol niya yung number of participants kasi maraming tao, kung masyadong marami, baka mag-away. No? So there was a clear understanding of in-explain niya, no, the rights of the party. So sabi nga ni Floro, that requires you to learn something about agrarian law also. No? Tapos, by way of qualities of a mediator, patience, intervention, and research, no, for both of them. No? Kailangan, sabi ni Floro, it's not enough that you rely on the facts given to you during the endorsement. Tignan mo rin, no? So there must be some sort of investigation also. So for Ma'am Vicky, that helped because that helped her in her shuttle mediation. No, meaning to say, bago pa magharap yung mga parties, nag-usap na sila. So she has an idea already of how to handle the mediation. Okay? So, and for both of them, importante yung full understanding and cooperation among the parties that led to an amicable settlement. Okay? So, siguro yung dadagdag ko na lang, and lastly, so that we can close, doon kay Floro, sinabi niya na, and for both of them, I think the most important mediation technique that helped them was the caucus. No? Caucus, talking to the parties separately, and bringing down the tension, kasi minsan masyado ng tensionado, recess, caucus, and then shuttle mediation, and then explaining to the parties yung mga positions. It helped that both parties were cooperative. Okay? So, yun, thank you. So, sabi ni Zito sa akin, we are now returning to the plenary. So, thank you. Let's give all of us a round of applause, and we will see each other in the plenary. Thank you. Good afternoon.
Yes.
See you.
Thank you.
Round of
Attorney.
applause.
Thank you.
Thank you, everyone.
Thank you.
Thank you. Thank you. Thank you to everybody. Thank you.